Hello and welcome to Opinionated Season 2. In each episode, we'll take a controversial subject, present the arguments for and against, and then discuss what our audience thinks about the matter. This time round, just under 9,000 people answered our survey, which touched on 4 areas: universal basic income, nuclear power, university tuition, and the UK's constitution. We're going to be releasing the episodes throughout May, but that doesn't mean that you have to wait. You can check out the full series on our website right now and watch all of the season immediately. Silver level Patreon backers have automatic access to the full season immediately, so you can either get access through Patreon or just pay $3.99 to watch all 4 episodes ad-free right now. For a little extra, you can also get bonus content and access to the full dataset. More information can be found in the description. First things first, what actually is a constitution? Put simply, a constitution sets out how a country is to be governed and run, typically defining the checks and balances of government and any individual rights and freedoms. The best example of one being the US Constitution. Article 2, for example, defines the rights and powers of the president, while the Second Amendment famously gives Americans the right to bear arms. So what's up with the UK's constitution? Well, unlike the vast majority of other countries, the UK does not have a codified constitution. Rather, its constitution is an accumulation over time of different documents, precedents, and quirks. At its core, the Parliament is the highest body. In the words of UCL's Constitution Unit, this is the ultimate lawmaking power, vested in the democratically elected Parliament, to create or abolish any law. The UK's constitution comprises of a number of sources, particularly statutes and delegated legislation, made under the authority of Parliament, typically by government departments, the royal prerogative, judicial decisions and precedent, the ruling of courts, conventions, and international law. Statutes include the likes of constitutionally significant acts passed through Parliament, those affecting the relationship between the government and the people, ranging from the Magna Carta to the Parliament Acts, European Communities Act, Human Rights Act, and the Fixed Term Parliament Act. Brexit as a whole brought the UK's constitution back into the limelight, with the now former Speaker John Bercow going further than many speakers before him. Many, including Bercow himself, called for a codified constitution. So what are the arguments for and against codifying our constitution? The main arguments are around simplicity, transparency, accountability, and defined rights. An uncodified constitution makes it harder to actually determine what the state of the constitution is, and makes it seem to be easier to modify or manipulate it. Instead of having a single defined document, there are a number of documents, unspoken conventions, and practices all over the place. Having a codified constitution would allow for the simplification of the vast bank of statutes, case law and convention down to this one single document. With an unwritten constitution, the precise lines that mark out where the power of the executive ends doesn't exist, which means it's ultimately up to the interpretation of the circumstances. And that means there's no defined limit of accountability. Unlike the United States, the UK doesn't have true separation of powers, and instead has a fusion of powers. The legislature, the bit that makes the laws, the executive, the bit that applies the laws, and the judiciary, the bit that supervises that the laws are not distinct. Just taking a look at the House of Commons, we can see the massive overlap between the executive and legislature. All members of the government, the executive, are conventionally MPs, legislators in their own right. According to the UCL Constitution Unit, the UK has no de jure executive power to initiate legislation, issue decrees, declare states of emergency, veto, challenge legislation, or dissolve the legislature. With them stating, in our collection of constitutional statutes, there's not even an explicit statement of who holds the executive power. Nowhere is the office or role of Prime Minister explicitly defined, nor is there any indication given of the selection process of the Prime Minister and the Cabinet. So ultimately, where does the line between legal and political accountability lie? There are some areas of politics which are political, not judicial. A written constitution would ultimately mean that judges would compare Parliament's actions against the constitution, potentially undermining the principle of parliamentary sovereignty. Therefore, a written constitution could risk politicising the judiciary, due to, not in spite of, the flexibility of our constitution, allow for debate that actually makes people more aware of the circumstances, instead of blindly applying the letter of the constitution's clause without properly thinking about the consequences. The process is therefore reversed, thinking about the consequences, then applying the chosen option. However, the fluid nature of our constitution causes issues. After the 2010 general election, there was considerable debate as to who had the first right to form a government: the incumbent, Gordon Brown, or the leader of the party with the most seats, David Cameron. According to the Political and Constitutional Reform Committee of the House of Commons, the incumbent Prime Minister has, in theory, the right to remain in government until he or she has explicitly lost the confidence of the Commons. It's been argued by many that the incumbent Prime Minister is constitutionally required to remain in post until he or she is able to indicate a viable alternative to the sovereign. While the Cabinet Manual now specifies that the Prime Minister will normally be the accepted leader of the political party that commands the majority in the House of Commons, the Cabinet Manual isn't statute, it's just a convention, and one that could technically be broken if needs be. Then comes the rights of individuals. Most notably, the rights of individuals in the UK are enshrined in the Human Rights Act of 1998. The issue is that as a piece of primary legislation, Parliament, moreover the government, could technically amend or repeal it. There's no single, unimpeachable document in which individual rights are directly embedded. The uncodified nature of the UK's constitution means that people don't know exactly what the constitution means for them, and for their government at any one time. Academics, legal experts and judges are all needed to interpret exactly what anything really means. The argument goes that with a codified constitution, everyone has direct access to what their rights are, and what the duties and powers of the executive, judiciary and legislative are, allowing them to call them out or push for further action properly. But whilst flexibility is an issue, for others that's what makes an uncodified constitution preferable. The current constitution is unquestionably complex, but always evolving to deal with the times. Fixing it in place may remove some of the dynamism at the heart of the UK's constitution. A written constitution would enforce rules so fundamentally that they cannot be removed by Parliament themselves, constraining rather than enabling parliamentary sovereignty. A codified constitution could make it harder to respond to technological developments and challenges that arise. Royal prerogative powers can provide governments, and by extension Parliament, with the ability to swiftly act in times of crisis. For example, a codified constitution that forced MPs to be physically present within the chamber could have made movements towards a virtual parliament during the coronavirus crisis constitutionally impractical, and would have made the removal of hereditary peers again constitutionally burdensome. That's not to say that the current situation is ideal though. There is a weird incongruence when it comes to Parliament's power. Throughout last year, it became clear that Her Majesty's opposition did not have confidence in the government, yet it blocked the dissolution of Parliament by voting down motions under the Fixed Term Parliament Act. So while the House of Commons has a statutory right to have a say and block the dissolution of Parliament, it lacked that right in prorogation. Then comes the argument of tradition, and the practicalities of actually compiling a constitution. There would be immense political and legal difficulty in compiling a constitution that would truly be acceptable to all, bringing together common law precedent and somehow codifying conventions. Even when it comes to constitutionally significant statutes, there is disagreement from seemingly apolitical sources. The UCL Constitution Unit finds 18 constitutional statutes, including the Magna Carta, Parliaments Act, European Communities Act, the Human Rights Act and the Fixed Term Parliament Act. Oxford Constitutional Law finds 14, omitting the Fixed Term Parliament Act, but this was passed after the list was compiled. But the Political and Constitutional Reform Committee in the House of Commons found 28 constitutional statutes, going further and including the likes of the British Nationality Act, the Representation of People Act, the Freedom of Information Act, the Civil Contingencies Act, and the Equality Act. An uncodified constitution ultimately allows power to remain in the hands of the democratically elected parliament, rather than an unelected judiciary. In a report by the Political and Constitutional Reform Committee, a particular argument presented is that any study of written constitutions around the world shows that they only come into existence after a successful invasion, after a revolution, or some appalling failure in the polity and breakdown in a way that government and politics were operating. The current malaise in the UK is nowhere near these catastrophic moments, and does not require a fresh start and a radical new way of conducting government and politics. The UCL Constitution Unit, in a report discussing the pros and cons of constitution, advocates for status quo for 3 reasons. Further codification is unlikely to increase transparency. The key pieces of the UK Constitution which are not codified in constitutionally relevant statutes are written in other documents, the primary one being the Cabinet Manual. The second reason is that the codification is unlikely to make interpretation of the constitutional rules easier, and the certainty created by codification is probably overstated. Those drafting the consolidated text simply cannot foresee every possible constitutional problem that could arise in the future. And the third is that the UK's constitutional order functions relatively well without having a codified constitution. The UK is widely recognised as one of the most democratic countries in the world, with one of the highest levels of human development. In essence, if it ain't broke, don't fix it. So what does our community think? Firstly, we said that 2 other modern states, barring the UK, have not adopted a written documentary constitution, similar to that of the United States, and we asked our audience to name them, with the correct answers being New Zealand and Israel. The vast majority of our audience were able to pick the right answer, with 54.8% picking New Zealand and 46.7% selecting Israel. We then asked you whether you thought that the UK branches of government were separate enough, and our community overwhelmingly believes that the UK branches of government are separate enough already. We finally gave you a broader list of statements and arguments for and against a codified constitution, ranging from making the law simpler to tradition, and here's what you had to say about them. 57.1% agreed that a codified constitution would make the law simpler in the UK. 68.3% said that it would make the law more transparent. 72.1% agreed that it would make the law clearer. 55.4% said that it would limit the powers of each government branch. 68.6% said that it would give citizens better defined rights. 44.7% said that it would limit the UK's flexibility when passing laws. And 36.8% said that it's traditional for the UK not to have a constitution. So what do you think? Should the UK go against tradition and codify its constitution? Let us know your thoughts in the comments below. If you want to keep watching and find out what our audience thinks about these other topics, then be sure to head over to our website, where you can claim access to the full series through Patreon, or just pay to watch the whole series ad-free. Thanks for watching, and thanks for supporting TLDR News.